from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
It is my pleasure to welcome you to part 5 of a 6-week series entitled The People's Law School. And for the viewers who have been with us over the past 4 weeks, you know that we are emphasizing a particular area of law each week. And today it is our pleasure to talk about law in the workplace. And there are many laws and procedures that affect both the employee and the employer. And we're very fortunate to have on the program today 2 attorneys who are very qualified to address this subject. And we'll come to you again next week with our final week of this very important series. I first of all welcome to the program Harvey Richmond.
Tony.
Mr. Richmond is an attorney in the state of Idaho. He has his offices in Coeur d'Alene. And Mr. Richmond, I know from your appearance here before, you're most articulate, and we're very happy to have you back on our program today.
Thank you.
And next to him is John Shaleen, who is also an attorney in the state of Idaho. He too has his offices in Coeur d'Alene, and I've worked with John in relation to some other issues, and I know you're very committed and dedicated to the Conflict Resolution Center here in Coeur d'Alene, and we have that center that's very involved with this series, and we're very grateful to them. And John, welcome to the program.
Thank you, Tony.
And I'm very pleased to have our 2 regular panelists to be with us again today. First of all is Janelle Burke, who is also an attorney in the state of Idaho and a law clerk to a district judge in the 1st District of Idaho. And next to her is Steve Schenck, who is the Dean of College Relations and Development at North Idaho College, and I shall ask Janelle Burke to commence today's series of questions.
Well, there's no doubt about it that work is one of the most important aspects of our life. It's something that we spend a great deal of time at, and it's very important to us. I would like to begin by asking about a couple of kinds of testing that could take place in the work in your work situation. John, I think you've had maybe some experience with drug testing cases in which people, as employees, were asked to be tested for drugs and drug usage. What about those situations?
Well, it's a large area, Janelle. In general, there are some protections to employees regarding drug testing, both with regard to state and federal law. I would say that in general, an employer would be ill-advised to do drug testing for the purposes of an employee's maintaining employment. However, if the employer can show that the employee may be adversely affected being on drugs in the workplace, then the employer might be able to show a justifiable reason for doing drug testing. For example, the employee may work at a mill site, for example, where it would obviously be a bad idea for employees of that employer to be on drugs in the workplace. Loss of limbs, for example, might be one effect of being on drugs in that situation. In other situations, it's harder for an employee to justify doing drug testing, and therefore that's why I say that the employer would be ill-advised to conduct drug testing. Now, I guess the follow-up question might be, well, what if you have been tested for drugs without any justifiable reason? And if you've been, I would say that if you've been terminated as a result of a drug test, which was given without justifiable cause, then you may have a cause of action against your employer for reinstatement or front pay or back pay.
I think I should also add, as John said, this is a broad topic, but an employer can put in place a drug testing program at his workplace and make it universal so that it is not such that he has to suspect that you are high today to test you. He can create a circumstance where today we're going to test certain people and certain people are called in to be tested. But that's a uniform policy as opposed to articulating some specific reason.
Another problem that might arise is if drug testing is justifiable on the workplace, exactly when should it be done? In other words, does it matter to the employer, who otherwise might have a good reason for doing drug testing, what you do on the weekend? Well, Obviously, an employer isn't going to run out to bars and so on and test his employees outside the workplace. But on the other hand, it's certainly not inconceivable that an employee on a Monday might show some positive effect of drugs that he or she had taken during the weekend. So whether the drugs are still effective on Monday after a weekend's carousing is certainly a question that's hard to resolve from a legal perspective.
Now, another aspect of testing that sometimes occurs is polygraph testing. Harvey, what has been your experience with polygraph testing?
Janelle, I know this program is seen by more than just Idaho residents. In Idaho, there is statutory material that says you may not do polygraph testing, leaving out law enforcement personnel under any circumstances. It is a misdemeanor. However, not everybody is covered by that because some people are not within the state of Idaho. We have people in Washington and Oregon watching us. Those people, leaving out their own state statutes, are covered by the Federal Polygraph Act, and in that regard, you cannot use a polygraph as a tool to hire a person. If a theft is involved, you may use a polygraph retrospectively to examine that issue of theft, but you cannot hire and you cannot fire because of the results of the polygraph. And of course, there's now some new issues coming about in the courts as to whether or not polygraph will even be admitted in the courtroom. That, of course, remains to be seen.
As evidence.
As evidence, yes.
Steve Sheen. I'm just going to throw out a general question and let you both play with it for a while and see what we come up with. But you're both in legal practice. I assume that you handle cases involving employers and employees in the law. One or two. What are the hot topics? I mean, when you see employers and employees at odds and at the point where they're both seeking legal counsel, what's usually the reason behind it?
I think the most popular call that I ever receive begins with, "I've been discriminated against." And I ask, how were you discriminated against? And more often than not, the response is something along the lines of, well, my boss doesn't like me, and he likes him, and he promoted him, and he fired me. Well, unfortunately, that may be a discrimination, and his employer may be discriminating. That is not necessarily a basis to get your job back. Employers, certainly in Idaho, have a right to discriminate against people unless it is one of the listed items of discrimination under Federal Title VII or any of the other employment acts such as Age, Americans with Disability Act, Equal Pay Act, and there's a whole series of them. You must find the actual nature of the discrimination, because that word is overused. And if it comes in under a protected act, either state or federal, then you have some recourse. More often than not, people are fired without a reason, especially in Idaho, where you do not have a right to continued employment in the absence of a written contract or some handbook provision or a union contract. And under those circumstances, there is not very much we can do for these people, even though their employer flat out didn't like them for one reason or another.
John, are your experiences similar, or are there some other areas that you see that are commonly a source of difficulty between employers and employees?
Yeah, I'd say another big area is overtime wages and minimum wage. Frankly, more often it's overtime wages that I've seen. Also connected with that is the issue of justifiable termination of employees, and what are they entitled to vis-a-vis their accumulated benefits as of the time they're terminated.
Let me follow up real quickly on the overtime benefits. To the best of your knowledge, in Idaho or in broader areas, if federal law is applicable, is overtime something that everyone's entitled to, or are only some classes of employees supposed to receive overtime pay?
Generally speaking, only some classes of people are entitled to overtime pay. In general, those employees who are paid on an hourly basis are entitled to overtime.
Let me expand on what John said. People who are exempt as executive or exempt as administrative or exempt as professional do not get overtime pay. However, there is a very serious criterion that you must meet. So simply because your employer says you're on salary and therefore you get to get your wages, as we've agreed, the same amount every week, regardless of the number of the hours that you must work, i.e. more than 40, that just is not necessarily so. So that you must determine whether or not you meet those requirements. Some people do not know their hourly rate. They get the same amount every week. Well, it is found in the Fair Labor Standards Act. There is a procedure to determine what that hourly rate is. If you are entitled to overtime and have not been paid your overtime, then you calculate that overtime unpaid. It is paid at time and a half rates, and if you haven't kept a record and you are entitled to that overtime, you can estimate. It is the employer's obligation to keep records. And my attitude is a time clock is good for everybody. Even if you are salaried, worry about whether or not the time is accurately kept and whether or not you need to refer to it later.
Tony, do I have time to follow up on one? We made one other important point, I thought, John, about the rights of people who are terminated. If, unfortunately, you're fired, what can you expect from your employer in terms of compensation or accumulated vacation time or whatever?
Well, there's another big area. Basically, the answer depends on whether you have an employment contract with your employer. For example, if you have vacation benefits that accrue with your employment, say you get 2 weeks of vacation each year, your employment contract, generally speaking, should cover what happens to those vacation weeks if they're not used during a particular year. Are they carried over to the next year, or are they simply lost? Likewise, when you're terminated, if you haven't used your vacation pay, the employment contract should cover the situation where you haven't used your vacation pay, but you've been terminated before having an opportunity to use it. There are other benefits, of course, but vacation pay is one of those benefits that almost everybody gets as a perquisite of their job.
Both John and I have recently examined that very vacation issue with a use it or lose it provision in the contract of employment. And we are going to need an appellate court to tell us all what the answer is.
So what I'm really wanting to follow up on what Steve is saying, that if your employer says to you in a contract that you get 2 weeks a year or 3 weeks, whatever, can they legally say you can get it, you can even choose when it is, but if you don't use it, it will not accumulate over years? That's legal to specify?
It can be done. There can be a provision that says you may not accumulate more than the 2 weeks. If you do not use it within the requisite period that's set out, that you lose it. That is doable. But the employer must make that time available to you. And if you're a policeman, by way of example, and we've had riots in the community and there has been no time for you to take it, and you have a use it or lose it, has the employer really breached that aspect of the contract? That is an issue that I think will be resolved in favor of the employee in some cases.
I have what I call a mop-up question to finish this, and I want to go to another subject. But again, when the panel was asking questions, I was intrigued by the fact that there is a difference between someone who works on an hourly basis and gets so much per hour, and they're under contract 40 hours a week, and versus someone who's on salary. And if you are in an executive position or professional position, and you know that you're going to draw X amount of money for the year, most of those people are willing, in certain emergencies, obviously, to work outside of the normal hours. But if you had a situation where there was great demand put on you to do it every week, constantly, even though you're on salary, is there any legislation that covers saying that there is an unreasonable request that can be made, that you do have a right to some free time?
No, and I think your employer here at the school could make you work an inordinate number of hours, assuming that you're professionally qualified, and it may be an uncomfortable work circumstance, and the employer might be a bad employer using bad judgment. But if you're not entitled to overtime, you're not entitled to it. If it becomes extreme, then it's an argument whether or not it's within your contract or not, but you don't get paid for it.
Then I want to go back to the issue of discrimination. We hit on that earlier, but again, I think many of our viewers would like to be more specific that are not students of federal law, or even in the 7 states that we're in, there's different state laws. And some state laws become even more extensive than federal legislation in some of these areas. Harvey, I'll start with you. Why don't you take us through some of the protected categories, list those things for which a person could not be dismissed?
Well, there are the classic ones: race, religion, place of national origin, creed. There's a whole series of protected issues in under the Americans with Disability Act. People with certain handicaps, if they qualify as handicaps from the Act's perspective, you cannot hold that against them. Age, anybody over 40 may have a claim under the Age Act. Gender, of course, is a big thing. Equal work for equal pay, and we actually have legislation to protect that, has been an age-old problem. We've had circumstances where men, and they have to protect a family, they get paid more for the same work than the little lady, so to speak, and I use that in quotes, of course, who doesn't really need the money as badly. Well, we have legislation to avoid those types of things. There are some classic examples that are protected under Title VII, 42 U.S. Code, Americans with Disability Act, to name but a few.
And earlier you referred to the fact that there's some forms of discrimination that can take place and the law will not protect the individual. And again, states are different. I'll come back to Idaho as an example, and this will be my follow-up question. If I am your employer and I say, Harvey, I have told you now for 5 days to quit wearing that particular tie, and you refuse to do so, therefore I'm going to fire you, that would not be protected under
Absolutely
example.
not. I'm gone. I have no complaint. I can apply for unemployment and argue whether or not it was a reasonable demand. I may be entitled to my unemployment insurance, but I'm out of a job.
So employees need to understand when they come outside of those protected categories and areas, it is the question of whether or not one gets along with their employer, and they may find themselves, even though if they go before an attorney for help, that they may not have relief in the courts.
That's correct. Employers have a great deal of power, more than the average employee would like to grant him.
Okay. John, I have a question for you, and then I'll go back to the panel. Another dispute we hear in the employer-employee relationship is that sometimes, for whatever the reasons may be, an employee contends they've not been paid on time. So what are the laws that govern? How often do you have to pay employees, and how clear do you have to be about that?
Again, there would be a difference between whether an employee is working under contract or not. I would say that you're obligated to pay an employee under the law at least once a month, if I'm not mistaken about that. If you fail to pay on time, then as an employer, you become subject to demand from the employee for the wages that you haven't paid on time.
And penalties?
Potentially. If the employer makes up that pay on demand, then generally there aren't any penalties associated with that. Under the law in Idaho, for example, if you, for example, quit your job and you haven't been paid up to the date of your termination date, you can make a demand for any money that you haven't been paid up to that point. The demand, generally speaking, gives 5 to 10 days in order for the money to be paid. You have 6 months to make the demand. If you make the demand and it's not paid, then potentially under the law in Idaho, you can get treble damages. That is, whatever money you were owed times 3 plus attorney fees.
Okay, Janelle Burke.
These days, we're hearing a great deal about terminations that are the result of downsizing. Can you give us some advice for the person who finds themselves in a situation where their job is going away? The corporation has simply decided that they do not need all of the employees that they have. Let's start with Harvey. What kinds of recourses do employees have, and what's their best shot?
Regrettably, if an employer is making an honest business decision to downsize his employment staff, and he treats that downsizing fairly across the board, you don't have much available to you. Now, if it turns out that he only lays off or dismisses the women, then we get into an argument as to whether or not that is pure chance because he only let go certain departments and they happen to have more women than others, or did he really just want to get rid of the women because they may not be as favorable an employee? That would be a gender case. But if an honest employer downsizes and he takes 10% out of each department or affects one department heavier than another for a good legitimate business reason, you're out of work. What
about unemployment compensation then, John? Is that a time when that might kick in?
Potentially. That's an administrative remedy, both federally and in Idaho. That may or may not be available to an employee depending on their situation. Were they terminated for cause? Usually in a layoff situation, you're not terminated for cause, of course. So my expectation would be that an administrative decision would have to be made through the Department of Employment.
Steve Sheen.
I think one of the most traumatic things people do is apply for a job. And I do believe most employers try to do it right, but they always don't know what right is. What are some of the questions you can ask in an interview? Or maybe the better way to phrase that question is, what are some of the questions you can't ask in an interview?
You know, this is always tough, and there's federal legislation on point. And if I knew you were going to ask this for me, I would have had it right here. But to illustrate what cannot be done, which is probably easier, when you're asking for people to fill a particular job and a dozen people come in and fill out an application, there are some things you simply can't ask them. You can't ask them their religion. You cannot ask them whether or not they are physically fit to perform the job. You haven't been prepared to hire them yet. So they can't take a physical. Some of those technical questions about their abilities cannot be asked. Prior industrial accidents, we see a lot of that. That is a method of weeding out those people who have had the misfortune of being hurt on the job. And of course, we don't want them at our place of employment, some employers would say, so we'll get them out early. So we don't ask if they were badly hurt on the job. Have you ever made a workers' comp claim? It's an inappropriate question. And there's a whole series of them. And good employers today track the federal statute and know and instruct their interviewers. You can ask this on the first level, this on the second, and go down this list of what can and cannot be done. To enumerate them now without reference to them would be tough.
It's somewhat situationally specific, too. I mean, if you're interviewing a prospective firefighter, for example, it really makes a difference if that person can carry 100 pounds. So you might have, for example, height and weight requirements that would be specifically correlated to the requirements of the job. And in that case, you would probably be able to get away with asking those questions, since those particular characteristics of a prospective employee carry through or correlate to the requirements of the job. If you're being interviewed for a secretarial position, it makes no difference how tall you are and how much you weigh.
Let me turn to another common trouble area, and that's reference checks. As an employer, what can you tell someone about a previous employee, or what shouldn't you tell them about a previous employee?
It depends on who I'm representing now, if I'm representing the employer or the employee.
From the employer's perspective.
From the employer's perspective, the employer should be honest. If he is not honest, it will come back to bite him, I assure you of that. But he is not obliged to say anything. And some employers have a policy of simply saying, John was hired on the first day of June 1901. He departed on the 27th day of June 1907, and his highest salary was $12.50 an hour. End of reference. However, if you're going to give a reference and give details, and forget to mention that this man made physical attacks on females in the restroom, then you have made a very tragic mistake. You should have shared that with us, or not shared anything at all. So I think if I was to encapsulate this for you, be honest, be complete, or not give anything other than hire date, fire date, and salary. And many employers have a form that they follow very strictly, and they do not get emotionally involved and give too much in the way of details.
In relation to that, we have about 5 minutes left, and there's something else that comes up that all of this leads to. We're not talking about downsizing now, but let's suppose that we're talking about someone is a particular individual, not a number of employees, is fired on the spot, and there's no hearing, and they're out the door that day. What are rights of that employee? Does an employer have to give a hearing? What kind of due process is there concerning procedural rights?
Well, again, you have the employment contract and the at-will issue here. I would say that in any at-will employment state, you don't have to give a reason if you fire somebody on the spot.
But so you're saying some states have that particular type of law and other states don't?
Frankly, I'm not familiar with what some other states' specific
but
policies
I assume
might be.
From the comment you made that some states aren't all alike about what they require in legislation concerning procedures for dismissal.
Oh, yes, because in some states, certainly, you have a right to your job, and you simply cannot be fired on whim and caprice.
And so states are different in how they write.
Absolutely, they are.
Okay,
Plus,
then let me finish. Then, is there any federal legislation that governs that?
Not that I know of. Maybe you do.
I was just going to say that private employees and public employees may be differently situated in that regard.
Of course.
So that a public employee would have, in general, you would expect a public employee to have more rights not to be fired without cause on the spot.
Okay, let me go back to Harvey. Then, since some states that you've indicated have specific protections, in those particular situations, give me some procedures that an employer would have to follow, even though they may have real grounds for dismissal.
One is a name-clearing hearing. Simply because you accuse me of stealing doesn't mean that I stole. Now, Janelle may have said I stole, and Steve may have said I stole, but I'm entitled to come back and say, wait a second, there's a reason they said that. Janelle always hated me, and Steve used to date my sister, and she ran away. So there may be an explanation that I can give. That is a name-clearing hearing. I'm entitled to keep my reputation and explain that. Or I'm entitled to come in and present my side of the reason that you gave for discharge, other than a name-clearing hearing. But it is not a court proceeding. You're not necessarily entitled to attorneys or court reporters or tape recorders. In large measure, for the average worker, certainly in the state of Idaho, there isn't a whole lot of relief available.
But in states that have this kind of legislation, and if that hearing is not held, then you would have a possible litigation.
You have litigation, perhaps prevail, and get your job back and start all over again.
And John, you had said earlier that you understand that there is a difference, though, in public employment and private employment, and that when you say public employment, you're talking about both federal and state,
yes.
that there's likely to be more specific procedures.
Yes. For example, we had a case where a public employee was fired without being availed of this name-clearing hearing. I guess the long and short of it is that the employee was subject to reinstatement because of the failure of the employer to conduct the due process procedures required under the employment contract.
I'm so sorry to have to bring the program to conclusion. I know that the panel and I could ask both of you a lot more questions. You both have been very informative, and we appreciate it very much. And ladies and gentlemen, through the Conflict Resolution Center of the Inland Northwest, we've been able to bring you these 5 programs, and we'll bring you one more next week when we wrap up this series that we have tried to bring you that was very informative, we hope. Please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.